So let's take a look at part one. I just want everybody to be on the lookout for a couple things, and we'll come back to discuss it. The body language, especially in the very opening scene where Paul Newman looks like a defeated old man. And it's actually to the point where even his adversaries are looking at him from the other counsel standpoint. What's going on with this guy? Also concentrate on the very, very poor preparation of the witness by his attorneys. There's going to be a legal issue that I want to talk to you about. And finally, all of you should be looking for a very famous star sitting in the audience, okay? Someone who's been very much in the news of late. So let's take a look at part one of our scene in The Verdict.
Dr. Towler, page 406, contraindications of general anesthetic. Ideally, a patient should refrain from taking nourishment up to 9 hours prior to induction of general anesthetic. Does that sound familiar?
Yes, I wrote it.
Methodology and practice in anesthesiology, a general textbook on the subject, is that correct?
Yes, it is.
And you wrote it?
Yes.
Page 414. If a patient has taken nourishment within 1 hour prior to inducement, general anesthetic should be avoided at all costs because of the grave risk the patient will aspirate food particles into his mask. Is that what happened to Deborah Ann Kay? She aspirated food particles into her mask.
She threw up in her mask, yes. But she hadn't eaten 1 hour before admission.
If she had eaten an hour before being admitted to the hospital, then the inducement of a general anesthetic of the kind that you gave her would have been negligent?
Negligent? Yes, it would have been criminal, but such was not the case.
Thank you.
Mr. Concannon?
No further questions, Your Honor.
I got to ask you guys a quick question, okay? Over and above the body language, I think that Paul Newman did something actually pretty good in that case, in the sense that he walked over to the jury when he was asking the critical question. But just not to belabor the point, but I just thought his body language and lack of confidence was really bad. I'm not sure whether he was just saying, oh boy, this is my last chance, or he was just looked like he was defeated. I'm not sure which. More important from a trial advocacy standpoint is the extremely poor witness preparation here. We were talking off camera earlier, but it's so important to tell your clients, both in the civil and criminal context, don't volunteer, don't volunteer, don't volunteer. And I don't care whether it's a deposition or a trial, don't volunteer. Rick, how do you handle that with your clients, apart from banging their head on the wall and saying don't volunteer?
Well, I choke them also. That's another way to do it. It's funny. Doctors, more than any other specialty that I represent, have a problem with that. They're very bright people, most of them, and they're very well educated. And they often think that they can talk their way out of these kind of problems. And I find that before I get to them, they have a thought process that I'm just really going to be evasive in a deposition or even in a trial. And that will work to my advantage. That will work to my benefit. And of course, I have to tell them, no, that will sink your case. You've got to be very direct. Answer the question with a yes or a no, it depends, and then give a sentence or two explaining it, and the juror will love you because they'll think that you're very direct, you have nothing to hide. Volunteering, of course, is a disaster, and clients do it all the time because they think they're the smartest person in the room. Dr. Towler obviously did not follow the advice about not entertaining. And something that was very subtle thing that Dr. Towler did just now on cross-examination that shows that he did take advice in one regard. He was asked a question about that anesthesiology book that he had written, and he starts to answer the question, but he pauses. And then he says, yes, I wrote it. So he wanted to be a wise guy. He remembered, don't be a jerk. That's what my lawyers told me on cross. And he shifted out of that don't be a jerk mode, and he answered the question directly. But he couldn't help himself on the question about whether it would be negligent in this context to have the patient have nourishment in less than 9 hours.
He also volunteered on the question about the 1 hour, and he said, but that hadn't happened. But nobody asked him that. Okay. And this answer that he gave in response to the negligence question is just devastating. Nobody asked him that.
Right.
All he had to do was say yes or no. Yes would have been great.
Yep. Well, I don't want to ruin the ending, but he thought he had this in the bank, and he didn't know about something that was going to happen later.
Joseph, what about you? Do you tell your clients, especially your criminal defendants, when they're going to testify, don't volunteer? Do you say that to the witnesses you're going to call?
Well, can I go back a little bit?
Sure.
You were talking about Paul Newman's body language, how he seemed defeated. And I have to tell you, I use that body language frequently when I am cross-examining a state's witness who I know is going to be fully repudiated by a subsequent state's witness. And I use that demeanor, that defeated demeanor, because it makes the witness open up, he sees that I'm going down the chute. He wants to jump on me with football spikes, and they exaggerate and they go further and further from what I know is going to be the testimony of a subsequent witness, usually a fellow police officer, and he's going to crush this witness's credibility. So I lure them into thinking they're beating me, and they want to jump on top of me and do it even more. So I think I use that a lot in trials, and I walk away like, oh boy, I just got my ass kicked, knowing secretly that they just got their ass kicked. They just don't know it yet.
What about the witness preparation and cautioning clients? Don't volunteer anything. Just answer the questions.
I have to tell you, we certainly tell that to our clients. And a case that I had years ago, which was a totally unwinnable case, I tried it with my partner, James Seplowitz. And James prepped this witness over the course of 3 days. He went from, when we were questioning in our office, he was just awful, volunteering and stuttering and wanting to say things. James prepped him, and then I did his direct examination. I never saw a better defense witness in my life. And it had everything to do with the day after day of preparation that my partner did.
Rick, I want to ask you a question, and this is real. I just speak about Florida law at this point. I don't know that you could get away with the question about this negligence question. I mean, in a Florida trial, would a witness be allowed to say that something was negligent? I mean, it seems to me that's a jury question, and unless you're dealing with some kind of hybrid expert who could, give an opinion, that's really a jury question. I mean, how would you handle that type of situation if that were to come up?
Well, that's an interesting thing. First off, my witness would be prepared, I would hope. And I may not want to jump up and object to the word negligent and so on, because I don't want to necessarily portray fear about that issue to the jury. I think you're right. I think asking the witness about the ultimate question using the word negligence probably would be objection that would be sustained. On the other hand, in a medical malpractice case, at least in our state, the key standard is this: was the care of the defendant reasonable? The standard of care for any physician in this state is whether the conduct of the physician was reasonable within the prevailing professional standard of care, and the duty is reasonable. So I think that the way you would ask that question to not get an objection is, would you agree with me that failure to abide by this 9-hour rule made reference to in your own textbook that you wrote back in 1966 or whatever, that would not be reasonable, would it? And I think under that scenario, you're going to have no objection to that question.
Okay. But you agree with me, though, there's a problem with the way that question was framed, and certainly the way it was answered.
Yeah, but you know what? There's also the thought process, I'm going to get away with whatever I can. If the judge and my opponent are going to let me do it, I'm going to do it. And if nobody's objecting and there's no smackdown by the judge, I'm going to do it, because that's not going to get me reversed on appeal.
Joe, in drug cases in New Jersey, we have kind of a fiction that we utilize where we don't let the expert, give an opinion directly saying that this individual possessed those drugs with the intention to distribute them. Okay. Your expert has to really kind of dance around this with all kinds of hypotheticals. Is that true?
Yeah, there's no question about it. You can't get it's not a field of expertise as to whether or not someone was possessing them with the intent to distribute, so to speak. You don't go to medical school for that. You don't go to law school. You don't go to engineering school. You have street experience. And what we do, of course, obviously, is draw out all of those facts which would lead anybody, including a lay jury that doesn't know, into believing that, in fact, they must have been possessed with the intent to distribute. And the officer can talk about, in particular in our state, whether the drug was legal or illegal, whether it was the amounts in which it was possessed, the way it was packaged. And they can say, in my experience, when we've dealt with other drug distribution cases, we find them packaged in this way, in these amounts, hidden in these compartments in the car. And then, obviously it's up to the jury to pull the arrow in between them all, but it's pretty obvious.
Okay. So again, these are jury questions that ultimately the jury has to do, and it's improper for a witness to give his opinion on that. Right?
That's correct. It's not a known field of expertise.
Got it. Okay, I want to move on to, by the way, did you guys spot the big star that was sitting in the audience?
I know who it is because you told us. I can't find him. I didn't see him.
You don't recognize him because he's got hair on. He's wearing a wig. Okay, Joe, did you see who it was?
I'm afraid I didn't.
All right. Well, everybody, when you go back and look at this, at about 1 minute and 20 seconds into the scene, you will see sitting in the audience Bruce Willis, a very young Bruce Willis, but there he was. Okay.